No, I don't have no. From where are you?
From 702, I did this news. It's a recording device.
Oh, okay. Thank you.
Judgment in the matters of Thabo Bester versus Netflix South Africa and another case number 2025-147420 and Dr. Nandipha Magudumana versus Storyscope Pty Limited and another case number 2025-16001.
Before me are two urgent applications. One brought by Dr. Nandipha Magudumana and the other by Mr. Thabo Bester. Both bring applications against Netflix International BV, with Ms. Nandipha Magudumana also citing Storyscope Pty Limited as a further respondent. For ease of reference, and with no disrespect intended, I will refer to the two applicants as the Doctor and Mr. Bester, and the two respondents individually as well as collectively to as Netflix. There are some differences, but also much overlapping in the grounds sought for the relief against Netflix. In essence, the relief sought is to interdict from screening on the 12th of September the documentary named The Beauty and the Bester, pending hearings of Part B's as set out in the notices of motion. I first deal with the application of the Doctor. The relief sought in prayers 2.1 and 2.2 of the notice of motion is an interdict restraining the publishing, streaming, and broadcasting of The Beauty and the Beast on 12 September 2025 in its current form. Netflix must also be compelled to refrain from continuing showing, playing, and flighting the teaser, trail, hook of Mr. Sekeleni's, in brackets the Doctor's father's face and his voice until completion of the trial. Furthermore, Netflix must be ordered to take all necessary steps to modify the documentary where Judge Cameron speaks and is shown until the completion of the criminal trial. These orders must be granted pending Part B to be prosecuted. Part B will seek an order declaring the license agreement entered into the Doctor and Netflix as unenforceable and unconstitutional, alternatively for the court to give effect to the true intention of the parties. I must from the outset find that there is a total disjunct between Part A and Part B of the notice of motion. Whether the license agreement is set aside has no impact on the prior restraint order, the one being based on contract and the other specifically based on Section 16 of the Constitution. This is already problematic for the Doctor's application. The first hurdle the Doctor must overcome is whether the matter is in fact urgent. Netflix has argued that the urgency was self-created. In the founding affidavit, the urgency is set out in, and I quote, "The matter is sufficiently urgent to have be enrolled on the urgency that the applicant seeks," close the quote. The historical background set out the timeline, and the Doctor did not delay in prosecuting the application. A deadlock between the Doctor and Netflix occurred, and the deadlock was only reached on the 5th of September 2025. Furthermore, as an incarcerated applicant, the attorney for the Doctor, Ms. Reed, experienced challenges in seemingly passing instructions to her attorney. The matter thus could not be placed on the preceding Thursday, and I quote, "But in any event, the investigation of the matter and sourcing of documents went beyond 5 September 2025. The following facts are common cause. On 19 August 2025, Ms. Reed, the attorney of the doctor, received an image of the Beauty and the Bester. On 20 August 2025, Ms. Reed wrote to Netflix. In that letter, she expresses that, and I quote, "As early as January 2025, as soon as our clients became aware of the documentary, which was planned to be aired on Netflix," close the quote. She then repeated the concerns they had, but continues to say, and I quote, "We have since been made aware that Netflix plans to flight this documentary on 12 September 2025, with the trial already being made public." The letter ends with a request to Netflix to suspend airing the documentary. On 20 August 2025, the trailer for the documentary was indeed aired. This is 19 calendar days and 13 court days before the application is launched. On 26 August 2025, ENCA reported that both the applications are to proceed. This is not denied by the doctor in the papers. On Friday, 29 August 2025, a letter dated 28 August 2025 seeks a roundtable meeting. Also on 29/8/2025, Ms. Reed held an interview on ENC, stating that if Netflix did not give them an audience and resolve this outside court, this matter will proceed on an urgent basis to court. On 31 August 2025, Netflix wrote to Ms. Reed that bringing urgent interdictory proceedings would be a patent abuse of court proceedings. She then answers on 2 August 2025 that she needs to consult, this despite her threatening with legal action publicly, seemingly then without prior consultation. Ms. Reed persisted with seeking a round table, despite Netflix on 31 August 2025 making it clear that no round table will be entertained. On 4 September 2025, she again seeks a round table. On 5 September, Ms. Reed sends a draft unsigned notice by email to the attorneys of Netflix. This application is issued by the registrar on the 9th of September, and the notice requires that the respondents by 1700 hours on the 8th of September oppose and to deliver its answering affidavit at 12 o'clock on the 10th of September. The applicant will then reply by midnight on the 10th of September with the matter to be heard on the 11th of September 2025. From the outset, the attorney for the doctor's attitude that a court must entertain a matter on the 11th September, while the answer need only be filed on the 10th of September before midnight, is preposterous. Furthermore, setting out under oath that the investigation of the matter in anyhow went beyond 5 September is a fact under oath, rendering the matter not ripe for hearing a day before the screening. This matter is then proceeded with on the 11th of September 2025 in this division, as instructed by the Acting Deputy Judge President of the Gauteng Division, Johannesburg. The replying affidavit of the doctor is filed on the day of the hearing, with an explanatory affidavit seemingly seeking condonation without any notice of motion. The reason set out for filing the document so late is that the answering affidavit is 60 pages, the delay is not excessive, and the doctor has strong prospects of success in obtaining the relief. No condonation is granted for the late filing of the answering affidavit. The applicant had set the timeline. She cannot now blame Netflix for a comprehensive answering affidavit that they had to compile in absolute haste. Submitting that a replying affidavit can be filed just 2 hours before the hearing as not being excessive is rejected. There are no strong prospects of success on Part A. In any event, the replying affidavit contains new matter, not covered in the founding affidavit, which is trite, is not allowed. Furthermore, submitting under oath that the replying affidavit is compiled by means of improvisation, and I quote, render this affidavit of no value. My decision on urgency. In an urgent application, Rule 6 in brackets 12 of the Uniform Rules of Court require that the applicant shall set forth explicitly the circumstances, what he or she avers renders the matter urgent, and the reasons why he or she claims that he could not be afforded substantial redress at a hearing in due course. As found in the well-known matter of East Rock Trading 7, in brackets Pty Limited, versus Eagle Valley, Granite and others, in brackets 11/33767, close the brackets, square brackets 2011, ZACPYHC 176, Norchi AJ reiterated the trite principle that the procedure set out in Rule 612 is not there for the mere taking. An applicant must set out explicitly the circumstances which it averred to render the matter urgent. Furthermore, the applicant, most importantly, must state the reasons why substantial redress would not be obtained in a hearing in due course. In the Gauteng Practice Manual, Pretoria, it is set out that the normal times will be abridged and a deviation from Rule 6 will be permitted only where the matter is urgent. The degree of abridgment and deviation must, of course, be commensurate with the case and must be justified in the founding affidavit. I quote, "The degree of relaxation should not be greater than the exigency of the case demands. It must be commensurate therewith. Mere lip service to the requirements of Rule 612 in brackets B will not do, and an applicant must make out a case in the founding affidavit to justify the particular extent at the departure from the norm, which is involved in the time and day for which the matter must be set down. A party must thus set out why the matter was not placed before the Thursday at 12 to be heard the Thursday at 12 to be heard the next Tuesday at 10. Self-created urgency is fatal to an application. Self-created urgency is the urgency which stems from a deliberate inaction until the hour of reckoning. In commission for the South African Revenue Services versus Hawker Air Services Pty Limited, 2006 in brackets 4, SA 292 in brackets SCA, the Supreme Court of Appeal found that where the application lacks the degree of urgency, the court can decline to exercise its power for that reason alone to hear the matter. I quote, "The appropriate order is generally to strike the application from the roll." Close the quote. The Constitutional Court in A Party and Another versus Minister for Home Affairs and Others, Moloka and Others versus Minister of Home Affairs and Another, 2009 in brackets 3 SA 645 in brackets CC at paragraph 65 found that launching urgent applications on short notice and at the very latest date should be avoided as it places undue pressure on the parties and specifically the court. In the Economic Freedom Fighters and Others versus Chairperson of Powers and Privileges Committee and Others, in brackets 23230/23, close the brackets, 2024, dated 8 February 2024, it was found that where it is expected of a court to digest the contents on a matter on short notice and then expect judgment in the space of a day is wholly unreasonable, and such matter should be struck from the roll. The application for the doctor was set down the day before the streaming of the documentary. This is simply inaction until the hour of reckoning. It is common cause that already on 20 August 2025, the doctor and Ms. Reid knew that the documentary would be screened on 12 September 2025. The trailer was in fact aired on 20 August 2025. This is 19 days, close to 2 weeks in court days before the launching of this application. Even if a court should take into consideration that consultation is difficult with an incarcerated person, she had, according to her affidavit, had telephonic consultations and in-person consultations with the doctor. And Ms. Reid should have obtained the necessary permission to have an in-person consultation with the doctor any day after 20 August 2025. In response to Mrs. Reid's letter dated 29 August 2025, Netflix attorneys advised Ms. Reid that the doctor's demands regarding the documentary are declined. It is also set out in full why a round table will not be held, yet no application is launched. In a letter dated 2 September 2025, the attorneys for Netflix expresses surprise that she has to obtain instructions to bring legal proceedings, as she had already publicly threatened such action, and she could have only have done so had she obtained instructions to do so publicly. Surprisingly, on 4 September 2025, Ms. Reid still persists with requesting a round table. It was quite clear by that time that no round table was to be held. Ms. Reid cannot be applauded for persisting with such request when that request had long been denied. It is trite practice that if an undertaking is sought and not given, or a demand is made and not adhered to, a Rule 612 application must be issued immediately. Furthermore, an opposing party cannot be expected to react to informal notices of motions. This is also not a practice of our courts. The reasons for the delay is without merit, and the urgency is self-created. The replying affidavit and heads were filed on the day of this hearing. This despite the directive of the acting deputy judge present in the Gauteng division, Johannesburg. This application has not complied with the rules, the practice directives, or the case law, and has placed undue pressure on the parties and the court by bringing it a day before the screening. It was wholly unreasonable. But more importantly, the doctor can obtain substantial redress in due course. Part A is not about media institutions using contractual clauses to divest the doctor of her constitutional rights. That relates to the disjuncted Part B. The right to a fair trial, dignity and equality is the basis for Part A. Substantial redress for all these causes can be found. As stated or as relied on by counsel for the doctor, contrary to what he seems to think the matter says, Kriegler AJ specifically sets out that there are forms of prejudice that affects the right that you are innocent until proven guilty, because doubt will be sown not only on the public but also to the accused's family and friends and colleagues. He finds that this prejudice is unavoidable and unintended byproducts of the criminal justice system. So complaining about this is unfortunately byproducts of the criminal justice system. A defamation claim or a dignity claim can be instituted and damages can be sought. I cannot in any way find that the screening on the three utterances which they find to make the doctor guilty or affects her right to a fair trial has any merit. The matter of media television sets out the interplay of Section 16 with other constitutional rights. The Court of Appeal went as far as to find that prior restraint can only be granted if the prejudice is demonstrable and substantial. There must be a real risk that it will occur. Not one of the phrases relied on can be interpreted as attacking any of the constitutional rights of the doctor. I find that the application is not urgent and it is struck from the roll. A de bonis propriis cost order was sought against Ms. Reed. I have exercised my discretion and the order of costs is as follows. The applicant is to pay the costs on scale C. I reiterate, the application is dismissed. The applicant is to pay the costs on scale C. I now turn to the application of Mr. Bester. Urgency is relied on or is sought to interdict Netflix from broadcasting Beauty and the Bester, pending the declaratory relief in Part B that the documentary violates his constitutional rights to a fair trial, equality and dignity, and his personality rights. Furthermore, that Netflix was not entitled to proceed without his consent or participation. Once again, the first hurdle that the applicant must overcome is that he must make out that the matter is indeed urgent. I do not, for the sake of time, repeat all the case law that I rely on again, as well as the setting out of Rule 612, as I have done in the doctor's matter, but in the written judgment it will be set out. I therefore then turn immediately in applying those principles to what is before me in the Thabo Bester matter. In the founding affidavit, the urgency is set out as that on 20 August 2025, it came to Mr. Bester's attention that Netflix intended to release the trailer on 12 September 2025. He consulted with his attorney, and he again consulted in person with his attorney on the 22nd of August 2025. His lawyer demanded in a letter dated 22 August 2025 that Netflix immediately remove all material, advertisings or references to the documentary from public platforms by 25 August 2025. This engagement continued with Storyscape directly, including the dates of 20, 21 and 26 August, which was not disclosed in the founding affidavit of Mr. Bester. Mr. Bester then launched this application on the 26th of August 2025, setting the date for the 9th of September 2025. Netflix had to oppose by 29 August 2025, and the answering affidavit had to be filed by the 4th of September 2025. The applicant did not comply with the Trite Lunar Lunar furniture matter. First of all, by setting out why he could not comply with the practice directive, that the matter be placed before 12 o'clock on the preceding Thursday to the Tuesday. Nowhere in the application does Mr. Bester expressly address this fact, and furthermore, or more importantly, he does not at all in his application set out why he will not obtain substantial redress. There is not even a single averment in this application setting this out. The quoted case law is clear that this is an absolute requirement, because if substantive redress can be obtained, the urgent application must fail. But in any event, Mr. Bester can obtain substantial redress. Defamation can be sued for. The case law is clear. Furthermore, the right to silence, the right to a fair trial, and the right to be innocent until found guilty is not in any way affected by the utterances referred to. No judge will be influenced by any documentary. Witnesses will be exposed to cross-examination. The public will form an opinion, but that is a byproduct of the criminal justice system and does not affect the rights of Mr. Bester as claimed. The equality issue was not addressed and is simply bad in law. In both matters, information about the doctor and Mr. Bester is firmly in the public domain. In fact, it has been set out in judgments in the bail application and the appeal against the bail, and in the High Court and in the judgment of the Supreme Court of Appeal. Never called by its name by the applicants, but the prior restraint, which is the correct defence, has been addressed by the SCA in the Media Television Pty Limited trading as ETV matter versus the National Director of Public Prosecutions 2007 in brackets 5 SA 540. As already stated, this is the matter that this court must follow. The principle is set out. The court went as far as to say that prior restraint can only be granted if the prejudice is demonstrable and substantial. It is a real risk that it will occur. Speculation, as argued in this court, is not sufficient. I am therefore satisfied that this application too did not comply with Rule 612 in that it did not address substantial redress, and in fact there is substantial redress in due course. For that reason, this matter is also struck from the roll and the applicant is to carry the costs. The court will adjourn.
High Court now, which has just delivered its judgment in the urgent application filed by Thabo Bester and Dr. Nandipha Magudumana over that documentary. Now, here's Criselda Lewis watching developments on that front. So, Criselda, the judge also choosing to first deal with many elements. Let's listen in.
Say anything at this point in time. Let me rather go consult first. Yes.
The cost order, quite hefty. Do you think that was unfair or fair on the judge's part?
Look, the cost at the end of the day, we just go with what the court has decided. But yes, there are heavy costs, especially when you look at the fact that the client is based in Consult. So it's not an easy type of a consultation to do. There are processes that one needs to follow. Even if you could perhaps maybe ask for whatever, you can't even consult after hours. It's near impossible. So hence I'm saying that our situation are really different. You know, it's not that the client is in Leeuwkop, the client is in Kroonstad and under strict correctional services processes and procedures. So it's not really that easy.
Ms. Reid, apologies there. Let's just first get your reaction to the matter being struck off the roll on behalf of your client.
Yes, it's, like we've said that it's not an easy one. Yes, it has been struck off the roll, but we really tried by all means to meet the agency, and our circumstances are different. And at the end of the day, it's not a matter of when you are told that you can maybe go to court. Our conversations with the respondents was never about go to court. Yes, we are the ones that said, let's try and negotiate before we go to court, because we didn't want to waste the court's time. And in their conversation, it was never that fact that it basically what they were saying was that you don't have a case. You have been ill-advised. And when you get that information, you have to go and consult, and you are threatened with costs. So it was basically a difficult one to maneuver, because on one part, you are told that you can't go to court, and then on the other, you have to take instruction. And the client, when a client wants their voice and their case to be heard, what else can you do?
We heard in the matter yesterday, Dinana, that there seems to have, as you say, have been ill-advising to Dr. Nandipha Magudumana. Who ill-advised her, and what happened there from her legal team?
Look, I can't really talk much about my colleagues. You know, I got in when the contract was already done, but from the papers and the consultations that I had was that there has been commercial arrangements between Storyscope and Mrs. Magudumana, and a license agreement as well, which was entered into. So the two are not in sync. So, and that the reason why she was insisting on the agency and to stop the production, because there are prior commercial arrangements, which Storyscope is also not disputing. They're in the papers. You know, Dr. Magudumana was entitled to give a view or input on the production. It is there.
Ms. Reid, we heard in court yesterday, and I raised this because it's something that we heard in court, the suggestion by Advocate Tembeka Ngcukaitobi speaking about the fact that Mrs. Magudumana was paid for this a commercial transaction. Are you able to tell us how much she was paid?
Okay, there was never payment directly to Dr. Magudumana. If there's any payment, it was basically towards it was used for the legal fees from the papers that I looked at, and it was claimed to be for, I think, the archives or whatever. Yes, and I'm a bit hesitant to mention the figures at this point in time because there's confidentiality that is signed, but I think if you head in our arguments, probably you'll be able to also find the figures, but I can't really say that myself.
There was also demands given that her father not be part of the documentary, and a big part of this as well coming from Mr. Bester's side is that this may somehow impact the trial. Is there anything that he says that could perhaps be furthermore incriminating?
I think from our side, firstly, yes, Dr. Magudumana was not aware that her father was participating in the documentary. And when we raised it in January of this year, they claimed that, or they didn't even claim, they specifically stated that it is factually incorrect. And they assured Ms. Magudumana that there is no such. And hence, we stopped, or Mr. Mutlung at the time didn't do anything because these are your partners. So you have to trust whatever that they are saying. And then on the 19th now, this documentary is coming out with the voice of your father, which then confirms the risk that was raised in Jan which is what we're trying, or Mr. Mtlung was trying to avoid as early as Jan, but it was ignored and denied by Storyscope. Yeah.
Right, Dinana Reid, who represents, of course, Dr. Nandipha Magudumana, and in just about a moment, we're going to speak to Courage Morero, who is the lawyer who's representing Thabo Bester. We'll get just some comments from her in just about a moment, and hear what her remarks would be relating to the judgment, of course, striking the urgent matter of the court role for lack of urgency. We'll speak on other matters relating to exactly. In fact, let me bring in Courage Morero, who is the attorney representing Mr. Thabo Bester. Let's get your reaction, first of all, Courage, to the matter being struck off the roll.
We are disappointed that the matter was dismissed. As you heard the judge, our matter was dismissed on the basis that the court finds that our client has substantial redress that's available to him that he can bring at a later stage, and that prior restraint in this event is not the only adequate redress available to him. Yeah. So we are extremely disappointed because obviously we view that quite differently. We do not believe that bringing damages at a later stage will substantially restore the harm that is being done to our client. But, you know, you come to court, you argue your case. At the end of the day, it's up to the bench what they find.
And what's next for your clients? I mean, he's been having these blows quite a bit in the courts. We saw it with Showmax. We've seen it now with Netflix. There could be more productions that are being produced. What's next for him?
Yeah, that is exactly the problem that we have, that with the court not granting our client the right to protect himself until this trial in Bloemfontein is finished, then there'll just be more people coming. I expressed yesterday, because I was also asked about the issue of Showmax, that are we now saying that if somebody is violated and the person who violates them gets away with it, then the next person should also be allowed to get away with it, and the client is just supposed to fold his hands? I do not believe that my client is the type of person who would ever just sit back and fold his hands and allow people to continue maligning him. So should anything of this nature happen again, I'm not saying we will be instructed, nor am I saying it will happen, but I mean, should it happen, I suspect that he will still continue want to fight to protect himself.
Sorry, Attorney Morero. Yesterday we heard Attorney Muafrika say that it is not necessarily that Bester escaped from prison. Are you confident that you'll be able to prove that indeed he did not escape come November?
Okay, I do believe what Advocate Maila was saying is, and this is true, right? I mean, it's not a fabrication. There are many ways to depart from a place. Yes, the place in question here is prison, but the argument is that is precisely what is before the court. The court needs to determine, A, did Thabo Bester leave prison? B, how did he leave prison, right? It's not a foregone conclusion. So the idea that he escaped, that's a conviction on his part. And we're saying we cannot be allowed to make pronouncements on issues that are before a court, that are yet to be tested, where evidence is yet to be led, where even a plea is yet to be entered, right? So basically, Advocate Maila was merely stating what is a fact. There are many ways to depart from a place. You don't necessarily always have to go out running. I mean, to put it in simpler terms. Yeah.
And you speak about a plea. Is that something you're considering?
No. Remember, when I say a plea hasn't been entered, that's the process of the trial. They accuse you and then you enter a plea. So the charges are there. We're still doing pre-trial things, case management. So we haven't even gotten to a state where we actually hear what the accused are pleading, whether they're pleading guilty or innocent. We don't know yet. No pleas have been entered as to the record. But already there's a foregone conclusion in the public that, of course, this man escaped, as though there's only one way to depart from a place, and that's by running away.
Advocate Magudumana made a lot of reference to the SCA judgment, where a lot of different facts were laid out within there, and he relied on that to say that a lot of the allegations are already out in the public eye. But Advocate Magudumana didn't really respond to that, and I think, to me, it was the crux of why I think the judge found in the way that she did that it's already in the public eye. So I just wanted to see if you had any response to the fact that one of the highest courts in the country, or is already stating some of these things as, I'll use the quote, as a foregone conclusion.
And that is exactly the problem that we have. So remember that SCA matter, my client was not even part of that application. That was done on behalf of Dr. Magudumana. He was not even part of the proceedings. But this statement was made. So we sit here where if an honorable court can make such a pronouncement, what then about our lay citizens who are sitting on the couch watching Netflix or watching the news? Then it would follow, then they would also be, inclined to make such foregone conclusions as well. So that is why we brought this application here. It's not about what are you afraid of that the people will say, because remember, whoever is participating in the documentary, whatever they're saying, our client still has the right to institute whatever applications for damages or actions for damages that he may see fit at the time. But we haven't actually had sight of the documentary. So the issue we're trying to avoid was a further forward into this wildfire, as Advocate Maila had explained it yesterday, that's already going on, that our client is being seen as somebody who escaped from prison. And that hasn't actually even been proven in court. His side of the story hasn't even been heard. And he wants to tell his side of the story, mind you. He's very eager to have his side of the story told. But he hasn't had that opportunity, and not for lack of trying, because the trial hasn't come to that point yet where we can even hear from him. Yeah.
Courage Morero, who is the attorney representing Thabo Bester, reacting to that urgent application being struck off the roll. That of Dr. Nandipha Magudumana has also been struck off the roll. So this essentially means that the Netflix documentary is able to go ahead. Certainly has been much anticipation waiting for that, in light of some of the snippets that we've heard inside court relating to some of the sentiments that have been shared inside court, including the fact that Dr. Nandipha Magudumana's father, who was a co-accused in a criminal matter, has shared some sentiments there. Justice Edwin Cameron, and we also understand a celebrity who is also part of that documentary. I will certainly get to know much more of what is in it once it begins.
And it was quite interesting, Criselda, to listen to the judge as she was delivering that judgment there, going through the many layers which she was just peeling off as she was delivering that judgment there. She said that no reasonable court would be swayed a certain way, but just by merely watching a documentary, but a court would be swayed by the evidence before it, before dealing with that element and aspect of urgency. I'm wondering now, what does this mean now for Bester and Magudumana going forward, given that there was another failed attempt with Showmax just before this?
Yeah, in fact, from the judgment, you would have heard a judge say that the urgency is self-created, and basically that the applications had not complied, and basically placed, undue pressure on the parties, which was unreasonable. And the reason why the judge had mentioned that aspect pertained to the aspect where papers had been submitted late. You also heard yesterday Advocate Thabo Bester, who's representing Netflix, talking about papers that had not been filed on time, which exerted due pressure on the opponents to get this matter off. And basically, talking about the fact that the application for Dr. Magudumana, was set out a day before the documentary, and they knew it had been aired 2 weeks prior to the trailer being out. So even if there'd been consultations, which we heard from her lawyers, there'd been difficulties in terms of consultations with her, the court basically found that that should not have been an excuse. They knew that this documentary was coming, and basically should have brought this application much earlier than that. So basically saying that the urgency itself was self-created.
Right, that's our very own Criselda Lewis.